Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where are we coming from today? This is beautiful Kamiak Butte right outside of Pullman, Washington. But Illinois, we need to talk again. You guys just, if you didn't have bad luck, you wouldn't have any luck at all. As it turns out, we had a very important and devastating ruling come out of an Illinois court as it relates to the Cook County assault weapon ban. They managed to drop that on Monday when all the rest of us were freaking out about the Supreme Court turning down Snope and Ocean State. But we need to take a look at this ruling because now that the Supreme Court has decided that they aren't really interested in resolving this issue, this is the kind of stuff we're going to see over and over and over. So today, let's spend a few minutes and let's talk about another Illinois court upholds their assault weapon ban. Okay, America, coming to you again from the beautiful Palouse out here in eastern Washington, just outside of Pullman. We are going to have to talk about the Cook County assault weapon ban. Many of you around the country are going, the Cook County assault weapon ban? Yeah, you see, when you live in a state like Illinois that doesn't have state preemption law, you can actually have local governments create their own firearm bans. Don't believe me? Ask Rob Bevis over there in Naperville. He'll tell you all about it as well. The case we're talking about today is Viramontes versus Cook County. This is a challenge to Cook County's assault weapon ban, okay? Hey, another quick thing I need to let you know is I didn't even know this case came out on Monday. I wonder why they picked Monday because, again, we were all freaking out about what happened at the United States Supreme Court. So special thanks to my good friend Todd over at Freedom Steel, who not only tipped me off about this, but also sent me the opinion. Now, this was before a 3-judge panel of the 7th Circuit. Already, I know you guys are starting to shudder in thinking that, but this is what I want you to understand, America. You see, now that the Supreme Court has decided to turn their back on assault weapon bans, you're going to see a lot of these civilian disarmament jurisdictions go for broke. And the problem is they're going for broke by bastardizing the rules of law. For example, we all know that the rule is in common use, but they've turned it into in common use for self-defense. And I'm going to show you exactly how they can use that to absolutely screw the petitioners in this case. Well, of course, you could do what other courts have done and just say, well, the Second Amendment doesn't even cover these kinds of firearms. Or you could do what other courts have done and just say, well, they're more appropriate for military use. Or you could just say there's a more nuanced approach and it's relevantly similar. There's 1,001 different ways that they can disarm you. But I do want you to understand that with this in common use for self-defense, what we see in Viramontes is exactly what's going to happen. Because what they're basically saying is, hey, you never established the record. Huh? Yeah, you never established the record to show us that these types of arms are in common use for self-defense. And it begins to show you the absolute impossible task, okay? Because proving that they're in common use, well, that's easy. And they know it's easy, and therefore they have to add on to the test. But being able to prove that this particular platform of firearm is used for self-defense, which we all know it is, but the ability to prove it with a multitude of incidents, well, that remains virtually impossible just due to traceability. Now, I mentioned to you already the case of Bevis versus City of Naperville, and I can assure you that the 7th Circuit, yeah, they hung their hat completely on that because, as you know, in the Bevis case, they also said that there was an insufficient record to establish that semi-automatic rifles are in common use for self-defense. That allows a 3-judge panel of the 7th Circuit to rule, the challengers here have failed to develop a record sufficient to justify a different result. Now, going back to that impossible test that they created in Bevis, they are now going to apply the same standard here to Viramontes, allowing the court to rule. We held that the plaintiffs had failed to show at the preliminary injunction stage that the covered firearms materially differed from machine guns and military-grade weaponry, which the Supreme Court instructed can be banned under the Second Amendment. Now, here's the thing. The court makes a big deal out of the fact that Viramontes counsel essentially refused to develop a record. I was not privy to the litigation, and I'm not here to criticize counsel because, candidly, I don't know if the result was going to be any different. But the court certainly wanted to make a big deal out of the fact that Viramontes and plaintiffs' counsel had never established that these firearms were in common use for self-defense. As the court ruled, Over the following months, while the county retained expert witnesses and obtained reports that support its view of the Second Amendment scope, Viramontes declined to do the same. Now, I want to point something out, and again, I am not trying to criticize plaintiff's counsel here because it appears that a record was developed, but it was just not a record sufficient in the eyes of the Seventh Circuit. And it was a record that was developed on a lot of declarations and other exhibits that were filed late in the discovery process. But the Seventh Circuit gets the rule. In response to the county's statements of undisputed material facts, Viramontes submitted 105 exhibits ranging from articles to surveys in an apparent attempt to supplement the record that he had previously elected not to build. And again, by creating this absolutely impossible test, a legally impractical and actually legally unnecessary test, the Seventh Circuit hangs their hat. Viramontes appealed, but his challenge falters for want of adequate record. We held in Bevis that it is the plaintiff's burden to demonstrate that the text of the Second Amendment, viewed through the lens of historical tradition, protects the regulated conduct. That is a completely bastardized test, because the test is does the plain text of the Second Amendment cover the activity? And the activity here is possessing a semi-automatic rifle, so the answer is yes, it does. And so what the Seventh Circuit, what the Fourth Circuit, what the First Circuit, what the Ninth Circuit are doing here is they are taking the second step of Bruin, trying to incorporate it into the first step to make what? Yes, that's right, the ability to establish the necessary proof actually legally impossible. And ultimately, because they say that this is no different than the record that we had in Bevis, the Seventh Circuit rules. Bevis upheld the constitutionality of this very ordinance, at least preliminarily. Though it left open the possibility that a better developed record might affect the final analysis, Viramontes' failure to build an adequate record here dooms his challenge. Now that is the effect of allowing these renegade courts to establish a fake rule of law of in common use for self-defense. At the end of the day, this is a balancing test that has been injected back into the equation by these courts that are hell-bent on civilian disarmament. And so even if Viramontes would have proven time and time again that these firearms have been used for self-defense, would that have even been sufficient in the eyes of this court? Listen, America, you might as well get used to this. You might as well buckle up. You are going to see a whole lot of very similar rulings. Now that the United States Supreme Court has decided that they have no interest in the Snopes case and has rejected that petition, that gives carte blanche to all the civilian disarmament jurisdictions around the country to continue to bastardize the rule of law and to continue to disarm lawful and responsible gun-owning Americans. Okay, the case once again is Viramontes versus Cook County. We're going to link it up down below so that you guys don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. You click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.